The commission is back in session. Thank you, our first working group. Our second working group, since I caught some smiling, you did notice my initial admonition, right? And we expect you not to drone on with a lecture, but to entertain us with inflection points and things we should be thinking about as we try to reconcile all the comments we're likely to get. Thank you.
Thank you. We have the slides. While we're waiting on the slides, let me introduce myself. First of all, let me thank the commission for this opportunity. My name is David Kesselman. I am a practitioner. I've been practicing antitrust law for almost 25 years. I've represented both plaintiffs and defendants, and I also advise companies on antitrust issues. I've also been teaching antitrust since approximately 2009 at Loyola's Law School in Los Angeles. With me is another member of our working group who also is my colleague, Abiel Garcia. Abiel can introduce himself more fully, but Abiel also represents both plaintiffs and defendants in antitrust litigation. He's also a former Deputy Attorney General in the antitrust section for the state of California. And just briefly, in terms of who is on our working group, we did have a cross-section of practitioners and academics. So we had Professor Mark Lemley from Stanford, Professor Steve Tadelis from Berkeley, Professor Justin McCrary from Columbia, Professor Babette Boliak from Pepperdine, and our practitioners were Kevin Turia and Brantley Pepperman from Quinn Emanuel, all of whom have extensive background and experience in antitrust. So we're gonna try to keep this interactive. We've taken your admonition seriously. We do have some slides to use as a jump point. Let me start from the get-go that you can be assured that there will be plenty of inflection point discussions because our group tried to give the commission the background on what is a well-known topic right now, which is the impact of technology platforms on the competitive landscape. I will say that, as you saw in our report, there was not a firm consensus on what to do about that. So to the extent you're going to get input from myself or from Abiel, to some degree, that's going to be our opinions just based on our experience, but we will try to flag where it's very clear we did not have a consensus from the group as a whole. So next slide. And the key question that our group was tasked with was, should California enact antitrust legislation focused on big tech, specifically big tech? And we did not come to a consensus resolution on the question, but what we did is we've tried to lay out for the commission the current state of play of the various opinions on that topic, and then we'll fill in with some of what's happening both at the federal level and with the state of New York in particular, and a little bit, although it was not the emphasis, a little bit about what's happening in Europe. At that part, I'm going to turn it over to Abiel Garcia, my colleague, who can give you at least a high level of what some of the legislation, some of the ideas are, if needed, to address big tech. Next slide, please. And so this is probably obvious, but in California, we are a huge hotbed and have been for decades for technology. The technology workforce is larger in California than anywhere else, approximately 1.5 million employees. Tech in 2021 accounted for 16.7% of the economy. Next slide. And so for purposes of our working group, and this is basically true of the literature in general, big tech tends to refer to, the largest platform companies, Alphabet, which is the parent of Google, Amazon, Apple, Meta, the parent of Facebook, and Microsoft, and the impact of these platforms is huge. Next slide, please. And so our group ultimately came to three basic questions that we thought the commission should consider. One is, should the recommendation be to the legislature, no legislation specific to big tech, just maintain the status quo, meaning whatever the Cartwright Act is empowering the AG and private plaintiffs to address, then that'll be enough, coupled with what's happening at the federal level. The second is whether there could be legislation that could address big tech, but it wouldn't be specific to big tech. It's we should expand the current Cartwright Act or the current antitrust laws in California to include unilateral conduct or to address what is colloquially known as, monopolists. We don't have that, as you well know, from the presentations and the papers. And we're going to come back to that because, at least personally now, speaking for myself, and I think speaking for Mr. Garcia, at the end of the day, if you asked our opinions, that's going to be where we would suggest the commission consider focusing on. The last part, which was the part that perhaps is most contentious, but is also the hot topic in this area, and that's, should there be legislation to specifically address tech platforms? Next slide, please. And so just very quickly at a high level, you've heard some of this based on some of the other working groups, but what were the arguments? What's the arguments in the academic community, in the practitioner community? You've heard some from the submissions from others. Arguments in favor of maintaining the status quo is, look, new legislation that targets big tech, that could stifle innovation. I heard the comment or the question earlier, could that lead to companies leaving California and going to Texas? So that's one of the big concerns that has been raised. I'd like to come back to that, when I'm given an opportunity, because I do think there's some responses to that. I think it's a serious issue, but I also think there's some responses to that. Second argument in favor of maintaining the status quo is related. California could be viewed as less hospitable. And then third, and this gets to deeper antitrust issues. Look, there is a view out there that the market can correct itself, that there's a concern about overreach that we have seen play out in the tech space and in the online space in particular, that some of the leading players from 25 years ago, AOL and Yahoo, they are no longer the leading players. And we've seen the advent of Microsoft and then more recently, Google, Amazon, and others. And so there may not be a need for this kind of tech-specific legislation. Next slide. So the arguments against, and again, you've heard some of this today from the merger group, but there is a real concern among a number of scholars and practitioners, they've sometimes been called neo-Brandeisians, that modern antitrust law does not effectively address the consolidation of market power, particularly when it comes to the big tech platforms, that we've now had 20 or 25 years where Apple and Google and others have become entrenched, and we're not seeing the kind of advent of nascent competitors being able to really disrupt and create new competition in this space. And the reason, at least according to these folks, is that big tech has managed to create these walled gardens. They've gotten so big, there's so much network effect and benefits from economies of scale. They've made it difficult for anybody to be able to break through. And that is a sea change from where we were 20 or 25 years ago. And so for some of these folks, they do think we need specific legislation to prevent big tech from acquiring nascent competitors and stifling competition. And so my colleague is going to get to that in a moment. That's the impetus behind, for example, Senator Klobuchar's legislation that's pending in Congress now, that's very big tech specific, but it's not just on the Democratic side. There is legislation also that's been introduced by the Republicans and bipartisan legislation as well that we'll cover at least at a high level to give you a flavor of what's out there. Next slide. So one of the areas that there was, I believe, a little bit more consensus, I don't want to speak for the group, but there is a view that, look, if we don't need to do specific big tech legislation, there may be a space where if we can introduce legislation in California to address single firm conduct, that would be enough to encompass all industries, but including big tech. But that's with a caveat. And the caveat is simply imposing the existing federal law, Section 2 of the Sherman Act, the current jurisprudence of the last 20 to 30 years, maybe 40 now, has been to make it much more difficult for enforcers and plaintiffs to be able to bring suit and actually win. And we can talk about the reasons behind that. There was a real effort, Professor Kolka referenced it, Chicago School Scholarship and others dating back to, let's say, the 1970s and 1980s, where there was a concern that antitrust had gone too far. There was an overreach. And so they tried to shift the emphasis of antitrust away from what some would characterize as concerns about concentration and more about concerns over consumer welfare and pure price. And so the question is, if you did make a recommendation to the legislature, could it be done in a way that would differ from existing Section 2 law? That was the recommendation ultimately from the group you heard, I believe, last month, the Single Firm Conduct Group. And Mr. Garcia and I will talk about that in a little bit. Okay, next slide, please. So again, there has been proposed federal legislation now pending for the last 3 or 4 years to address big tech. So far, Congress has not yet passed any of it. The legislation tends to borrow from European Union law, particularly there's a focus on the 2022 Digital Markets Act, which in Europe changes what's required to actually hold some of the digital platforms and others with dominance, not necessarily monopoly power. It's a lower threshold. We don't yet have, and my colleague Abia will address this momentarily, we don't have a lot of empirical data yet on the impact of that. But the language and some of the spirit of that is what infuses what you see in some of the legislation. In fairness, that legislation that's been introduced by Senator Klobuchar and others, it actually doesn't flow purely from what's happening in Europe. There are folks who would say it actually returns Sherman Act jurisprudence to its origins for the first half of the 20th century until we saw the Chicago School and others narrow what was deemed anti-competitive, at least under Section 2 of the Sherman Act. So the proposed legislation, which we're going to walk through just at a very high level, is meant to address what the legislation, most of it calls covered platforms. Google, Amazon, Apple, Facebook, Microsoft, and now TikTok, which might be in its own category. There's separate concerns being raised about TikTok. Next slide. So while we did not have a consensus, and I want to make that clear, there were people within our group that thought there was no need for any new legislation, or if there was, it shouldn't go beyond the existing federal law without more study. We did come with at least suggestions of a framework if the commission decided that it wanted to make a recommendation to the legislature to enact big tech specific legislation. These are kind of 3 high-level points that we pulled from most of the existing proposed legislation pending in Congress. And the 3 high points are, look, it should be a tech platform with some connection to California. It should include 50 million or more active US users. Its market capitalization should be substantial. The number we've seen in some of the proposed legislation in Congress is 550 billion. Two, and this is where this overlaps a little bit with the single firm conduct committee's recommendation. There would be a presumption. This would change the law. So there would be a presumption that it would be unlawful for one of these covered platforms to engage in self-preferencing, giving themselves priority over others, or discrimination of some kind, giving priority to one company over another on their platform, or restricting interoperability, the ability to access various platforms, or tying, requiring you to buy one product or service on condition that you have to take another product or service, or using data from a covered platform to support another business line. And so the final recommendation here, and it dovetails a little bit with what you've heard from the merger group, is any acquisition by a covered platform should be subject to automatic merger review by the California Attorney General. The idea being that, look, if this is going to impact California, then it's important that California's Attorney General be given notice and be given an automatic opportunity to review, regardless of dollar amount of the acquisition. And the reason for that is there's been a real concern expressed, at least by some, that Facebook and others have acquired smaller companies, maybe below the threshold reporting requirements, but that truly posed a competitive threat or could pose a competitive threat. And so there's a need to address that from the threshold. Next slide, please. So at this point, I'm going to turn this over to Mr. Garcia. He's just going to walk you through kind of at a very high level, what's out there percolating in terms of the proposed legislation, if it is something the commission wants to consider.
Good afternoon, commissioners. So we're going to take a look at a couple pieces of legislation. I kind of want to group them into buckets for you all. So the American Innovation and Choice Online Act and the Open App Markets Act really are addressing platforms specifically, and we'll see in some of the provisions that they go after very specific big tech participants. Moving into the trust busting for the 21st Century Act, the Digital Consumer Protection Act, and Competition and Antitrust Law Enforcement Reform Act. These are broader views on how to reform just the laws generally, but also take into account very big tech specific issues. And then finally, we'll look at some of the revisions to the Donnelly Act in New York, which is their antitrust statutes, and the 2022 Digital Markets Act, which really looks at the abuse of dominance standard that I think a lot of people are talking about nowadays. Next slide. So the American Innovation and Choice Online Act was introduced by Senator Klobuchar in 2022. It specifically covers platforms, so anyone owned or controlled by a publicly traded company, at least 50 million US-based monthly users or 100,000 US-based monthly active business users. Covers net sales in the US of 550 billion or average market cap of 550 billion, excuse me. And then if that market cap or annual sales is not met, there's another provision that could bring them in under 1 billion monthly active users worldwide. And then the language here is critical trading partnerships related to products or services on the platform. So that's what would entail a covered platform. Next slide, please. And Senator Klobuchar's bill would essentially make, if you're a covered platform, all of these pieces of conduct unlawful. So self-preferencing, discrimination that harms competition, restricting interoperability, conditioning platform access to purchase of service, using non-public data obtained from the platform, restricting access to data. There's a long list. I'm not going to read them all out to you. But this is specifically covering those covered platforms. Next slide, please. Similarly, Senator Blumenthal's Open App Markets Act is very similar. So a covered company, any person that owns or controls an app store for which users in the United States exceed 50 million. It defines an app store as very broadly. So publicly available website, software, app, or other electronic service that distributes app from third-party developers to users of a computer, mobile device, and so on. Next slide, please. Again, specifically spells out unlawful conduct, very similar to Klobuchar's bill, the American Innovation Act, but also adds in a layer of security and privacy of users. So both of these bills have not been passed yet. They have been presented and on the floor, but have not really moved far. But these are examples of what the commission could look at for very specific big tech types of legislation, right? So it's effectively just going after platforms at a very kind of targeted way. Comparatively, the next set of 3 bills that we'll talk about, so next slide, please, look at more of a holistic reform. So the Trust Busting for the 21st Century Act legislation proposed by Senator Hawley in 2021 is much, much broader. Proposes legislation that amends both the Sherman Act and the Clayton Act. It includes provisions to address this idea of dominant digital firms, which in looking at the bill does kind of look like some of the abuse of dominance standards we'll talk about in the European Union. The Federal Trade Commission would actually have the power to designate dominant digital firms, which is exactly what the EU does right now under the DMA. They can actually name gatekeepers, is what they're called in Europe. The Senator Hawley's bill would prohibit any acquisition greater than $1 million, basically presuming an unfair or deceptive act under the law, and that would be for any dominant digital firm that the FTC has designated. And then again, it also bans dominant digital firms from self-preferencing. Next slide, please. So this is some of the language about actually amending Section 2 of the Sherman Act. Again, this is in the context of if the commission is going to recommend a broader set of legislation proposals, this is something you could look at and borrow from in terms of what it could recommend to the legislature. So here, importantly, I think that's the first bullet point, which is once either substantial market power or detrimental effects are established by preponderance of the evidence, so a little bit of burden shifting there, there's no need to define scope of relevant market or established market share. This makes it, as a practitioner, easier to bring cases. And I guess there was a question about the merger-specific issues of whether if anti-competitive effects and pro-competitive effects, if one outweigh the other, can you have an essentially anti-competitive merger, but if it can help consumers, could you let that through? So here, Senator Hawley's bill kind of lays out the standard and says pro-competitive effects of conduct must clearly outweigh anti-competitive effects. Now, this is within the monopolization context, but that standard is a little bit clear and laid out. And then in terms of remedy, the bill actually requires disgorgements of profits, which is in practice harder to get right now. It is something that it can be available, but it's not uniform and it is difficult. Next slide, please. Yeah.
May I ask a question?
Of course.
On your prior slide,
Yes.
is the second, let's see. No, maybe it's the
One before. There we go.
Yeah, is the second bullet point controversial?
There hasn't been a lot of discussion about the second bullet point, and within the group, I don't think there was a lot of discussion about it. My personal view, it does change the standard, right? Right now, it's hard, you know, in a wash, it generally goes to the defendant, whether or not, if there's, you know, if the anti-competitive effects and pro-competitive effects are kind of neutral, you can't tell. But I think this would be controversial, and I'll let David jump in if he wants to.
Yeah, so I think this would change the standard pretty dramatically. It really depends ultimately, as we heard earlier, on how courts would interpret this. Right now, if you're a plaintiff and you sue, you've got the burden of proof to show that the anti-competitive conduct, and a lot of the language in the modern cases says substantially outweighs the pro-competitive justifications. And so, that's in the eye of the beholder a little bit, but this is an effort to shift the burden more to a defendant to have to justify what they're doing.
So it's not, the issue isn't the word clearly, it's reversing the polarity of proof.
Well, candidly, I don't know what clearly means, because from an evidentiary point of view, if it means clear and convincing evidence, for example, then actually that would be a much higher standard of proof as well. But yes, it would also be a reversal.
Next slide, please. So these are the proposed amendments to the Clayton Act. So no person with market cap exceeding 100 million shall acquire the stock or assets where such the effect of the acquisition lessens competition. I think controversially, no need to establish market shares or concentration in any particular market. And again, this is for acquisitions done by what has been deemed a dominant firm by the FTC. And then no acquisition shall be presumed to not substantially lessen competition because the parties do not directly compete at the time of the acquisition. So this really gets to vertical merger ideas, meaning just because you're in a vertical merger, you don't get to assume that there's not going to be substantially less competition, which would be a departure from where we're at today. Next slide, please. So the Digital Consumer Protection Commission Act, this is Elizabeth Warren's bill, Senator Warren's bill. This is, again, another example of a broader type bill that it addresses big tech. It's clear that it's aimed at big tech, but it's not very specific in terms of we're targeting a covered platform, essentially. So covered entity collects, processes, transfers personal data, excludes government services and a couple other parties. A platform that meets certain requirements on ownership and control, user count, partnerships, very similar to the two tech-specific legislation we discussed earlier. Would meet the standard of a dominant platform. Next slide, please. Sorry, copy here. So the big one here that I think is worth highlighting, the big change is the actual proposal of a Digital Consumer Protection Commission. So it establishes an entirely new regulatory authority that's independent and bipartisan. From my read of the legislation, it looks like another kind of FTC type body, promotes competition, but also importantly, privacy for consumers and strengthening national security. So this bill has both the antitrust aspect, but also consumer protection and privacy. They would have full authority to investigate, enforce, and rulemaking authority, just as the FTC does. 5 commissioners appointed by the president and would establish a public complaint process. So very similar. Next slide, please. So this is the Competition and Antitrust Law Enforcement Reform Act, or CALERA, which is also a bill by Senator Klobuchar introduced in 2022. This is a very comprehensive bill. It scours pages, and it really tries to get at the heart of some of the problems we've been talking about today and some of the things raised in the mergers and acquisitions discussion. So stricter standards for permissible mergers by prohibiting mergers that, quote, create an appreciable risk of materially lessening competition, which is a very different standard than what we're looking at now. And I believe is one of the recommendations, or one of the burdenships we talked about earlier today. The other standard, though, is unfairly lowers the prices of goods or wages because of a lack of competition among buyers or employers. So this is addressing the monopsony issue. So we always think about a monopoly. Monopsony is the other side, the buyer issue. It also, for larger mergers or mergers that meet certain concentration thresholds, the bill shifts the burden of proof to the merging parties. So again, changing the standard like we looked at, what we talked about in the previous slides, where you would have to prove that your merger is not anti-competitive. Prohibits exclusionary conduct that presents an appreciable risk of harming competition. So again, changing standards for mergers that we currently, in the current framework. And then I think one of the more interesting positions is establishing a GAO report on successes of merger remedies in recent consent decrees and the impacts of said mergers, which we currently do not have.
Can I comment on this just for one moment? So, we didn't give a fully comprehensive summary of CALERA. This is the legislation, but that second to last bullet point about exclusionary conduct, it's actually in the legislation itself, very comprehensive and really shifts burdens on specific conduct. And I'm raising that partly because if you go back to the presentation you got last time from the Single Firm Conduct Working Group about adding a provision that would address, essentially monopolization type conduct to the Cartwright Act, it's borrowing, I would submit, quite a number of the burden shifting provisions that you see in CALERA. You see that being added to their recommendation. And so I think it's interesting to note that. We can talk about some of that after if you have questions.
Next slide, please. So here now, moving away from kind of the broader legislation and moving into the abuse of dominance standard that we're seeing pop up in the United States, and then we'll move to Europe. So there has been multiple attempts to reform the Donnelly Act in New York, which is their antitrust act. And this legislation started, I want to say like 2 or 3 years ago, and has had a number of revisions since then. And this legislation is holistic as well, and it's trying to address all monopoly theory and mergers specifically, but not just big tech, but it does include big tech. Next slide. So the current version of the bill that has passed the Senate, but has not passed the Assembly, established a pre-merger notification requirement to the Attorney General, anything that meets the HSR standard. Now, this has changed from the first version of the bill that had a floor of $9.2 million. So any transaction that had a substantial impact in New York that was above 9.2 million would be reported to the New York AG. Now, there was a lot of commentary on that floor, and I know we talked a little bit about it with merger and acquisition, that the number was too low. The New York AG's office would be flooded with inquiries. In terms of, I think there was a question earlier about staffing. The New York AG and AG's office and the California AG's office are probably the 2 biggest antitrust sections outside of the DOJ and FTC. But that being said, I think it would be a significant amount of inquiries if 9.2 million was your threshold.
Quick question. Would this then be consistent with the Uniform Law Commission's recommendation?
I believe so.
If it met the federal requirement for reporting it, they didn't have to report to the
way it is
AG?
now, it would be consistent there. As was mentioned, this bill has the deputy Senate leader has run it 5 times, and 5 times he's passed it in his house, and 5 times he's failed in the Assembly, including this year. It also didn't pass there. But this version would be consistent. The other version, I did want to caution, because his first version had as noted, a very low threshold, and there was also a bill in Maryland that had an $8 million threshold. That's pretty much a non-starter for the business community. I'll just give you one example from my line of work. We frequently go to authors and buy the rights, exclusive copyright rights to make movies from their books. Those are always well north of that threshold. They get paid a lot of money for those important rights. That's a kind of transaction that would need to be reviewed. So for us, like in the motion picture sector, you'd be looking at thousands of times. We'd have to go see the AG and get the next movie approved. It's really not a good situation, and there's lots of other examples too. But the short answer is, overall, this approach would have been consistent with our current bill.
Okay, thank you. That's what I thought.
Thank you for that. The new reform also prohibits abuse of dominance, which we'll dive into a little bit more with the European Commission. But essentially, to establish dominance, it'd be 40% share of the market for the seller, 30% on the buyer side. It does enhance criminal penalties to individuals and corporations. It does permit antitrust class actions and recovery of damages and costs. One of the earlier versions of the bill did allow for treble damages, just like the Sherman Act does, but that was removed in the latest version. Next slide, please. So 2022 Digital Markets Act by the European Commission and European Union. Very controversial bill that just went into effect, I think, March 6th of 2024. So there was 2 years of leading up to it of getting ready, and then kind of went into effect 2 months ago. As my colleague mentioned, it's a little too early to tell exactly how it's going to shake out, but there have been responses from all the big tech companies that have somewhat adjusted their responses, the way their interoperability works, the way their app stores work in Europe. So the legislation covers gatekeepers, so the large digital platforms that we all know, Alphabet, Amazon, Apple, ByteDance, also known as TikTok, Meta, and Microsoft. There's a lot of different provisions, but essentially gatekeepers must share data with rivals, ensure interoperability with hardware, software features on the platform. The real aim of the legislation is to create greater competition within app markets and digital platforms itself. There's been a lot of commentary on what the DMA is going to do to big tech companies in Europe and how they're going to respond. There have been some movements by the European Commission to issue fines already. There are rumors about potential actions coming. But as of now, it's a little too early to tell how everything's going to play out. There have been an introduction of third-party app stores in Europe, but I haven't seen any that have really gotten traction. And so we'll keep an eye on that. But again, it's only been 2 months. Next slide.
So to wrap in terms of our formal presentation, I mean, the key takeaways, and some of this is obvious, big tech has an immense impact in California. There is concern about, big tech potentially, whatever the concerns are, they can be addressed by a single firm conduct piece of legislation, maybe not big tech specific. As we talked about, those proponents think, that the current law is inadequate to address the issues raised by the sheer size and power of these platforms. But the flip side, the critics, which some of whom I think you'll hear from today, are concerned about overreach and that could stifle innovation. So again, from the group's point of view, we did not come to a consensus on a recommendation for the commission. And that frankly was not our charge as we understood it. But I also understand that, you've asked for folks like us to come who have experience. And so, if I can take off my group hat and I don't represent any of the institutions, I will say that from my point of view, having done this for almost 25 years, there is a need to have some, at least I believe, some mechanism to address unilateral conduct in California. I think, our state is big enough and important enough. I mean, we are literally the size of a country. And so the idea that the Attorney General in California can only bring suit under federal law for violations when we have our own robust California law, and frankly, the law is clear that the Cartwright Act is not patterned after the Sherman Act. It's supposed to be broader. It's supposed to be deeper. It has its own history. And so I do believe there's a place, again, speaking for myself, for some type of legislation. I don't know that it has to be big tech specific. I mean, I think there is a place for what the single firm conduct group proposed to this commission, which I found to be very interesting. And one of the things they addressed, and I'll just comment on if that's allowed, is, look, they're addressing the fact that in the real world today, and I can say this from experience, small and mid-sized businesses, they're basically shut out from being able to utilize the antitrust laws for significant Sherman Act Section 2 violations unless they're able to team up and be part of a class action or there's some kind of litigation funding. Because at the threshold, the way the modern antitrust law works, you need an economist, and with due respect to the economists who serve an important function, to get past a motion for summary judgment in the federal court, you need a report that's going to cost millions of dollars. Most small business owners, even mid-sized business owners, that sticker shock, they can't do it. And so I can tell you from experience that we get calls regularly from folks that have issues, but as a practical matter, they're foreclosed unless they can get the kind of funding that's required to litigate under modern antitrust precedents. And part of this is what Senator Klobuchar and others are trying to address. And what I think the single firm group was trying to address, if you can create some presumptions under the law and move away from a requirement that puts the onus all on the plaintiff up front for a relevant market analysis and a full-blown market analysis, if you can show direct effects on competition, then that can be enough. And so in my view, again, just speaking for myself personally, I think what they've proposed is interesting. I hear the critics. I also represent defendants. I understand that some of this will need to be fleshed out, But I do think that this is a time for and an opportunity for reform. And so I really appreciate that the commission is giving us all an opportunity to weigh in on this at this time.
Are there questions from commissioners for this panel? Victor?
Hi. As a member of the commission back when we were working on mediation confidentiality and having spent 4 years on that draft legislation, having it go nowhere, as a simple realpolitik point of view, what you're saying is that if we follow these large efforts to specifically mention big tech, it's kind of dead on arrival because an army of lobbyists and special interests have stopped this stuff in Congress, have stopped it in New York and other places. So if the purpose is to actually pass something, isn't the realistic proposition, which you seem to be recommending, or your group seems to be recommending, is to focus on the single firm conduct, have aspects of the single firm conduct regulation touch on the problems with big tech, but never in any specific way target the big tech companies specifically, period?
Yeah, it's a great question. So let me say it this way, because I'm a little bit loath to speak for the group as a whole, but my sense of it was that, yes, I don't know if it's politics, although certainly that plays into it. We've seen all this legislation so far sit idle in Congress. But there was definitely a view, at least from several members of our group, including academics, that we've generally stayed away from legislating industry by industry under, our monopolization law, for example. And that if there's a way to have a broader, more prophylactic statute to address, including what's happening with big tech and big tech platforms, that seemed to be more palatable, at least to more members of our group. So that the short answer to that is yes.
But just to be a devil's advocate, haven't the antitrust laws targeted specific industries in the past? Telecommunications, airlines. So it's not unheard of to target specific industries.
That's true. But for example, a lot of that comes out of Congress, at least my memory and understanding. But that's true. And look, one of the things that, and I'm sure you're going to hear from others who are going to give testimony, on the one hand, and there is a lot of balancing here, the big platforms, the tech platforms have created, immeasurable innovations that are important. But the flip side is, if we get to a place where they have become entrenched monopolies, then we do have other examples in the past. For example, you said telecom, where when we broke up AT&T, or the government came in and broke up AT&T, which was hugely controversial, out of that breakup, we saw, at least for a while, significant innovations in telecom that we had not seen before. Now, there are some folks who think, slowly but surely, some of the bells are coming back together and some of the innovation is stopping. But, so yes, there has been targeted legislation at times, but I think there was a view that, there was a concern about unintended consequences from some folks in our group, that we have generally never focused on a covered platform with $500 billion. It's usually not a dollar amount per se to figure out who should or should not be subject to a particular law. And so I think there was more comfort in having a traditional statute that could apply to that, but also other industries as appropriate.
And one thing to add in, the first two bills that we discussed that did, have covered platform specific definitions. I think that one of the concerns that I at least have discussed and raised with the group is that you'll find a way around them, right? I could break up my company in 4 different ways as the subsidiaries, and maybe each app is US based on West, East, North, South. It's to stay under the 50 million requirement, or whatever the requirement is, right? Once you write the law, you'll find a way to get around it. And so I think if you're having these really hardline rules as to what a covered platform is, just ask, people to say, okay, this is the rule. How do we stay under that, right? And so I think you're right. I do think big tech specific legislation is dead on arrival. In my personal capacity.
There was a question raised earlier, if I just might respond to the concern about, if something were to be passed, whether it's single firm or big tech specific, to make California less hospitable, will companies leave? There was some discussion about that, on some of the calls in our group. One thing I think that, we've seen is, for example, California was at the forefront and had been for years with our Business and Professions Code 16600. Our non-compete law was the strongest in the country. So workers could move around. Other states like Texas allowed for non-compete provisions in contracts with employees. And yet, even with that, even with California having more restrictions, because of all the other benefits of being in California, including our research universities, the Silicon Valley, that actually, there was an argument in some research that suggested it's actually fostered innovation. And so the flip side of the argument about big tech or others leaving is, if you allow for more competition and nascent competitors to be able to rise up, it may be possible to actually see, more companies doing business because it's an even more hospitable environment, at least for the smaller startups.
Yeah, the other thing that occurred to me was, we had the concentration working group that also identified serious concentration in food and ag, healthcare and pharmaceuticals, entertainment industry. And if we were to go down the road of recommending a specific bill on the tech industry, wouldn't that raise a question? Well, why are you not also doing industry-specific legislation on these other ones that have been identified where there's concentration? Now, I know agriculture couldn't get up and leave California, but so that's what I've been sort of struggling with as well in this, at least as a philosophical basis.
And to follow up on that, has there been an analysis, like the commissioner just mentioned, of the problematic M&As in a particular sector or industry, looking at all of them altogether? That's one. And then the other, I wonder, is this a issue of enforcement? In other words, are our current laws not being appropriately enforced, or there's not enough resources to be enforced? And then you brought up that question about who does the analysis, right? And how small and medium-sized businesses are stuck with having to hire an economist or some firm that conducts those. Wouldn't we be better off as maybe an independent agency would be prompted to do that, instead of the burden being on that small or medium-sized company? I don't know if that's been explored before.
So let me address some of them, maybe not all in the order. You were first asking, I think, about, has there been research done on the tech industry? So the short answer is yes. Now, I know not everybody agrees, but the 2020 House Subcommittee report was a very thorough assessment of competition in the digital space and focused very much on the big tech platforms, and came to the conclusion that competition has been stifled. And so again, I know there are critics of that report. This was a staff report, out of the House of Representatives, but it was very thorough. And from that report came a lot of the proposed legislation that we've talked about today. Your other question, I think your second question is, can antitrust law be enforced now? Has there been a lack of enforcement? The 2020 House Subcommittee report actually said exactly that. At that time, the Department of Justice, with maybe one exception, really had not brought a Sherman Act Section 2 claim in almost 2 decades since its battles with Microsoft. And there was a real criticism that there had not been more enforcement focus on monopolization or attempted monopolization. So we have seen now under the very end of the last administration and the current administration, this proliferation of government Section 2 cases, Sherman Act Section 2, against Amazon, against Apple, Google, Facebook. We will see how all of that shakes out as they continue to wind their way through the courts. One of the issues that, critics say is, look, that's really good. We finally have the government doing what it had been doing decades before, but the law has gotten so much more difficult. A lot of these judges that they're facing, even though the current DOJ, the current FTC are authorizing these far more robust suits, and they're focusing on things like impact on employees and wages in a way that we have not seen in decades. The law, the federal law, has evolved in a way where you got to overcome a lot of these decisions. There's a real presumption in some cases against finding in favor of the government. So we'll see how all that shakes out. But I think there's real concern that, we may bump up against a Supreme Court, a current US Supreme Court, that will not favor more enforcement, and it may be left to the states, as it was back, say, in the 1980s, where the states need to step in, and it's one of the concerns about adding more legislation.
And then on the practical side, I mean, you raised the question on resource issues. I mean, to bring these cases, each one that David just mentioned is going to be millions of hours, spending, millions of dollars reviewing huge amounts of documents. I spent a lot of time doing this, and you're looking at these cases and terabytes of information, hundreds of millions of pages that have to be reviewed. I mean, there's now AI software that does help with this. It might lessen the burden a little, but I mean, you're talking about significant undertakings for each one of those cases, not just the one. And so I do think that from a practical standpoint, there is a resource issue because it's not just big tech that's doing things, right? And so you get constrained at the agency level as to which cases you're going to bring. I mean, I think one of the questions you had was about an analysis of the mergers. First, I'd recommend John Coco's book. It's fantastic. But a lot of these mergers and acquisitions that happen are under the HSR threshold. And so we don't really know what's happening. There's a lot of different acquisitions happening very quickly in the big tech space. And, the example that I always use is Meta, when, there's a public email from Mark Zuckerberg that says we're buying Instagram because he literally says the word nascent competitor, right? And that's an example of the identification of these mergers that big tech is looking at and ultimately follows through with.
And just to follow up on that, a case that I will confess I'm not a neutral observer on, because we did file a brief in support of one of the parties, but Epic versus Apple was a very big lawsuit that wound its way through the courts and then ultimately to the Ninth Circuit. And it was an example of a case where a federal judge said, Apple does not have monopoly power in the market being challenged. And so under federal antitrust law, I am not going to be able to find Apple liable. But the court clearly was troubled and found there was something wrong. And so they relied on the California unfair competition law, 17-200, and said, look, I don't need to make a finding of an antitrust violation if I can find that there's an incipient violation, a violation of the spirit, as the case law says, of the antitrust laws. And that's what she found in that case. And she said Apple was stifling competition. And the Ninth Circuit, it was vigorously challenged. The Ninth Circuit agreed with the judge that you could use California's unfair competition law in that way. But some folks have said, look, that's a good example where the federal antitrust law doesn't go far enough. Others have said California's law went too far. And so it's a real inflection point of some of these policy debates that are happening. And then interestingly, Epic sued Google because they wanted, and all of this flowed out of, it's more complicated, but essentially they wanted to be able to offer consumers an opportunity for in-app purchases in their game, for less money. Apple said no. They sued Google on similar grounds, slightly different, but similar. In that case, they actually prevailed in front of a jury. But there's a through point that the federal law has made it very difficult to bring these suits.
Thank you very much. We have less than 10 minutes left until the lunch break. Executive Director, I'm assuming immediately after lunch, we will go to the comments from panelists and the public comment, correct?
Yes, that is correct. With our remaining few minutes, I do have something we could deal with very quickly if you choose,
Which is not,
which is the consultant contract,
okay.
the antitrust study. So.
Yes, let's do that.
Okay.
We're going to
So-
use every minute.
Yeah, so if I could refer you to memorandum supplement 3, I believe. As you're all aware, Shoal Johnson, who has vast experience in antitrust law, has even been
Yes.
responsible for the treatise, et cetera, for years, has provided us expert support for the past 6 months, or at least paid for it for the past 6 months. So we're entering into a new fiscal year. What we're seeking is commission approval to amend the existing contract to go through the beginning of this fiscal year through next fiscal year for the reasonable sum of a total of $20,000. She charged $10,000 for the 6 months for this fiscal year. So for next fiscal year, it would be a total of 20. And if I may, I would like to seek a motion to approve the staff recommendation.
Are there any questions before we do that? Any questions from commissioners? Hearing none. I heard a motion and a second. Is there any objection? Motion passes.
Thank you.
Now, I've got a question for Kristen. Memo 28, the landlord tenant. Since we have 6 minutes, that's simply approving a memo which punts, correct?
That would be approving a draft report that we would be circulating for public comment. That is an item that Steve Cohen prepared. I don't know if he wants to turn on his mic and.
Great. Well, that answers my question, and then it's over to Steve. Are there particular controversial points in this one you would like us to consider?
No, thank you. There are no controversial points. It's just a question of the commission approving the draft tentative report as a tentative report to be distributed for public comment. It's our typical procedure. We have a report date back of August 30th. And assuming the commission were to approve this tentative report, we would do that and we would bring it back with any comments we received and the analysis of the comments. And that would be in furtherance of preparing a final report to the legislature, which is due December 31st.
Great, thank you. I had, and apologies, I had miswritten the name of who's in charge of this one.
We should see if there's any public comment.
Yeah. I've got one question, Steve, which is, I'm assuming there's been no change from what was previously discussed. I read through it. It looked like it's what we've discussed in the
That's
past
correct.
couple of meetings.
That's correct. The draft tentative report effectively takes what the commission decided in the previous memos that were presented and then just puts it in report form.
Great, thank you. Now, whoever is monitoring the public on our behalf, is there anyone who wishes to be heard from the public on this memo?
There are no hands currently raised. If anyone has anything to say, please raise your hand on Zoom.
Okay, and Steve, do we need a motion to do what you'd like us to do? Is there such a motion?
Yeah.
There is a motion. Is there a second? Is there any objection? Motion passed. We will adjourn for what, 30 minutes for lunch?
Yes.
We'll be back at 1:30 to pick up with the agenda where we left off. Thank you all.